What's up to my parenting and award tribe? This is Alicia coming to you with a topic that I think many of us think about in some ways or don't think about at all. And that's legal issues for us and our families and key considerations. So, for instance, a lot of us may think about being in an encounter with an attorney in a negative way, but there are numerous opportunities and avenues for us to be involved in our legal planning and preparations and things like that. And so I wanted to bring a lovely colleague of mine who is an attorney, and I will allow her to do her introduction in just a moment. But it was really important to me to have this type of conversation around what we as Black parents or our Black families need to be thinking about in the legal area, some of the key considerations, and again, taking away some of those misperceptions we might have about experiences in the legal system. And so, again, my lovely panelist, Miss Shonnese Stanback, I would appreciate if you give a little bit about your background and your law practice.
Well, thank you for having me, Alicia. I am, again, Shonnese Stanback. I am an attorney here in North Carolina. My practice is largely based in Wake County, so I mostly practice in Raleigh. I also do cases in Durham County, and I've been practicing family law for about 20 years now, of my 23 years of practice. Um, Mainly, what I do is I help parties who are getting divorced, parties, and whether it's just the straight absolute divorce or parties who need to separate property, if anyone needs alimony, spousal support. And I also work with parents who are having trouble navigating custodial time or child support issues.
Lovely. Thank you so much. And my audience are comprised of different types of parents. We have those who are in single family homes, those who are in marital unions, or they're co parenting. So I think a lot of this conversation will have relevance on different levels for different people. And so, given your work in the law field, when we think about the average family, what are some of the parameters for when they might seek you in particular for some of the types of services you provide?
Over the last 20 or so years, I think what I have found is that they are looking for the average family is looking for someone to help them deal with debt. If they're dividing up debt, if the parents or the spouses are separating, they're dividing up debt. They are dealing with a house, which is typically going to be their largest asset. Second largest asset is also typically going to be retirement. So dividing those things up, dealing with little things in the house, cars, furniture, things like that, and then as important, often more important, is dealing with custodial time if there are children involved in that family, and where the children are going to live, if they're going to live with one parent primarily, if they're going to live with both parents equally, if both parents live close enough to each other that they can have a fairly simple joint custody schedule. Also, dealing with decision making. That's always going to be a big issue, is how to divide up that decision making power. And then, of course, sort of the brass tacks of things, money. Parties want to know, am I going to be able to survive if we separate? Am I going to be able to have a roof over my head? Um, how am I going to deal with things like the equity in the house? My name's on the mortgage and I'm moving out. How do I get my name off the mortgage? Um, those are the kinds of things that we're talking about. Obviously, when there are children involved, there's going to be child support issues. And those things can be everything from just a monthly child support payment to, we've got one child that plays travel basketball and another child that's, involved in gymnastics. And those things cost money. And how are we going to divide those things up? How are we going to divide up who takes, our daughter to gymnastics and our son to soccer? Those kinds of issues. Unfortunately, some of the other issues that I deal with outside of money issues are the situations where there might be physical abuse, where there might be substance abuse, where there may be even infidelity in the marriage. So all of those things kind of come into play when we're trying to figure out what happens next. And unfortunately, those are kind of run of the mill issues. Those are the normal things that everybody deals with. And someone walking into my office, one of two things has happened. They've either kind of reached their breaking point and they haven't separated yet. So they're coming in to find out what what to expect. They want to get some lay of the land before they pull the cord on this and say, hey, it's time for me to move on. Or they've already separated and now they're like, okay, what do I do now? We have these joint accounts. How do I deal with this? Sometimes there's a stay-at-home parent who's worried about being able to pay bills because the other parent has moved out and they've kind of taken all the money with them. So those are the kind of things that, again, sort of, those are the average cases.
I'll get in a little bit later parts of the discussion to some of those resources that can be provided. But to step back, I think for a lot of us, when we think about, again, the legal system and things like that, it's almost like, a fantasy. It's what we see on TV. And so everything's so dramatic. And, like I said, it wraps up in the 30 minutes of whatever that series is. But on average, when you're encountering these families in need, is the natural conclusion sometimes these separations, or are you seeing people that in the process of working with you, they're like, you know what, we're going to work this out? So, by and large for your client base, are these people who you're seeing them through, or does that seem to be more drama than actually occurs in a day-to-day basis for your practice? So what is the usual mix of people and kind of what their 30-minute wrap up is like at the end of your time?
Well, I think it's funny that you bring up television, because I thought about that when we were discussing before about, even having this conversation, was that I think is probably one of our biggest frustrations as lawyers, is that what we see on TV is not what happens in real life. Family court is not nearly as dramatic in real life as it might appear on TV. And I think clients, unfortunately, want to rush to the courthouse because they want that moment of a judge, telling their spouse or their child's other parent, shame on you. And that rarely happens. But what I do see in terms of like what people, to answer your question, over the years, I've had a handful of people who have reconciled. And in the very beginning, when I first started doing family law, I had like a rash of people who were reconciling. And I thought, gosh, am I helping them do that? That's great. And then,
part-time as well.
Right. I think to be honest, I think the economy kind of drives that conversation a little bit more than me. A lot of the time, when people set foot in a lawyer's office and they're having that consultation, they've reached a point where they really need that, like, this is information that they're like, okay, I may not necessarily be ready to move out just yet or to end the marriage just yet, but I need to know, okay, what should I expect when this happens? What are going to be the hurdles that I have to deal with? One of the hurdles sometimes is just separating. Just because in North Carolina, you have to live literally in separate locations before you are considered legally separated. There's no document that you file or anything that says you're legally separated. You just have to live separate and apart, as the statute says, with at least one of the parties having the intent for the separation to be permanent for 12 months in a day.
Excuse me, 12 months in one day. One of the parties. It doesn't have to be agreed by both.
Yes. So, you may be the one that decides that this is over, I can't deal with this anymore, and you move out. And your spouse may be begging you to come back. They don't want the marriage to be over, but you've had enough. And if you stay separated for that 12 months in a day, and, we always advise that you divide up any property in that 12 months, because there's some other legal implications for not doing that. But let's just say that there's no property involved and you don't want any alimony and there are no kids and you just need to separate, you need a divorce. You stay separated for that 12 months in a day. When that one day has passed, you can file your absolute divorce. So for instance, today is December 22nd. So you separate on December 22nd, and on December 23rd of next year, you can file for divorce. And it takes, there's a process. It's not instant. There's a process and there's a short hearing. So within I usually tell people about 60-ish days, you'll be divorced.
If it's uncontested or?
If it's uncontested.
Okay.
If it's uncontested. The only way to contest a divorce in North Carolina is if you haven't been separated for the full year. But,
wow.
So we don't do the thing where the other party has to sign a document in order for you to agree to the divorce. That's divorce and dividing up your property are two completely separate things in North Carolina. So
and they're handled separately.
Yeah, they're handled separately. So But I mean, as far as like, like I said, people coming into my office is concerned, by the time they step through the doors, or by the time we've set up that consultation, they're ready to hear some information. Now, just like people do change their minds and decide, I don't want to have the consultation. That
Mhm.
happens. So sometimes people will get the information from the consultation and go, this is more than I want to deal with right now. And they've got the information and they decide, you know what, I'm going to try to stick it out for a little bit longer. I've certainly had many people who have had consultations even a year or two ago, and they'll come back to me and say, hey, we talked 2 years ago. I wasn't quite ready at that point, but I'm ready now. So, like I said, my experience has been that once you've kind of moved into the realm of getting legal advice, you're already kind of halfway down the road to doing whatever it is that you feel like you need to do. And that happens the same way with custody cases as well. Sometimes people just don't want to dive into the drama that can happen in custody cases.
Mhm.
And that's not necessarily courtroom drama more than it's just interpersonal drama. And so, they call, they get the information, we, have the consultation, and then, they mull it over. But again, majority of the time, once you've made that appointment, once you've had that appointment, they're already halfway down the road to doing whatever it is that they want to do.
And I think that's helpful because for a lot of people, when you actually go through the effort of finding someone, you go through the effort of setting up that appointment and sitting there, there's a lot of thinking that has happened for
Mhm.
whatever reason. And it is interesting that you are saying, again, the majority of people at that point, you're moving it forward. Are financial considerations some of the reasons that hold
Mhm.
people back? And I don't know if it's the experiences of working with the attorneys and doing all the things, but is it sometimes more fear-based and fact-based in terms of people thinking that money or costs could be it, or is it,
I think
maybe equal?
it's equal. I think that that's probably an equal consideration for most people. Um, you know, it's an old blues song, "It's Cheaper to Keep Her." My dad used to talk about it all the time.
Mhm,
And, for some people that is the case. But the reality is that going through divorce is not cheap. There's no inexpensive way to do it. If you have things to divide, or if you have children that you have to divide up time with, unless everybody is in agreement, which there are certainly less expensive ways to do it if everyone is in agreement. It's the problem comes in when people are not in agreement. And the less agreement you have, the more it's going to cost and the more time it's going to take. And also, you want to be sure that the person that you hire to represent you in this matter has the requisite experience, the requisite knowledge, that they are telling you what you need to hear and not necessarily what you want to hear, which I think is always a problem. But yeah, I mean, I think for a lot of people, they come in, and I think this is men and women equally. I don't think that this is, at least in my experience, it hasn't been a thing where it's just been a woman thing. I think that everybody comes in scared of what the future is going to hold for them. I think for everybody, it's a financial fear, but it's also kind of it's an emotional fear of, am I going to have good relationships with my children going forward?
mhm,
Is this person on the other side going to be able to co-parent with me? And in those situations, that's when we start taking into consideration things like mental health, mental illness, medical illness, other disabilities that might be factors, children with special needs, all of those kinds of things. So all of those things play into the fear. And that's, like I said, for both parents. And even when there aren't children involved, a lot of it is, like I said before, debt, dividing up assets. I earned all of this retirement during our marriage. And I think some of the most difficult marriages are the long-term ones,
mhm.
because, you've worked for, each of you might have worked for a company for 20 years or more, and you've got a lot of retirement assets, and you think that's my retirement, but maybe one spouse earned a lot more than the other one. And so they've got more in retirement than the other spouse who's worked just as long, but they don't have as much. But that retirement asset, those retirement assets that were earned during the marriage are marital property, and they're subject to division.
And does that vary by state, how that works, or is that
I
across the
I don't
board?
know. I'll be honest. I think in for the most part, because North Carolina, so you hear things like community property state and things like that. North Carolina is not a community property state; it's a title state. It's an equitable distribution state. And what that means is that the presumption of property being divided is that the court looks at what was earned between the date of marriage and the date of separation. And so I've told you that the date of separation is the day that somebody moves out and has the intention, and one of them has the intention for the separation to be permanent. And so once we've established the date of separation, then we can look at for instance, a 401k and say, okay, well, this party has $100,000 in 401k, but this party has $500,000 in 401k. And in situations like that, the court looks at apples to apples. So they're, not necessarily going to look at a 401k versus the equity in a house, because that's different types of money. But apples to apples, if we're looking at those two 401ks, we're going to add them together and divide.
And that's what happens in North Carolina.
Yeah, that's what happens in North Carolina. That's the general practice. Now, that's not to say that there aren't other factors. And that's why I say it's an equitable distribution state. So the presumption is 50-50, but there are factors that can lead to an unequal distribution in someone's favor.
Okay. What is a community property state? Like, what does that mean?
Yeah, it's kind of like everything that happens during the marriage. It's similar to an equitable distribution state, but I think in some states, they may look at things that you owned prior to the date of marriage, and that becomes part of the community property. Whereas in North Carolina, what you owned prior to the date of marriage is still yours. It's still your separate property. Say the other thing that is considered separate property in North Carolina is inheritance.
Oh, so if you came into the marriage and that had already been established.
Or if you had a parent that died during the marriage and they, left you a house, or you inherited, whether via will or intestate succession, which is what happens when you don't have a will. And it just, because of the way the laws are set up, you naturally got 100% of your deceased parent's estate. That's still your separate property because it is inheritance.
And it's not, they have no entitlement
unless that parent puts something in writing that would indicate that your spouse gets some portion of this. It's, there's always a rebuttable presumption is what it's called. But generally speaking, if you inherit something from your parent, or your great aunt Susie left you, proceeds from her life insurance policy, that's going to be yours. What you do with it and how you manage it is what's important.
Okay.
In terms of, like, you inherited, Aunt Susie's $100,000 life insurance policy 10 years into the marriage, but 5 years later, you guys are separating. But if you put that money into a joint account, you've got a problem. Yeah.
Everyone who's listening, now that we hope you're going to go towards divorce, think about these things.
Yeah.
That's very, very surprising, but good information. Okay. So when we think about those household accounts, you may want to have with this.
Yeah. It's important to make sure that, like, I will just say in general, for any kind of inheritance, particularly that results in money, whether, you get the life insurance proceeds, or there was a house that was sold and you got the proceeds from the sale of the house, that if you want to keep that separate, it doesn't mean that you can't use it during the marriage, but you don't want to mix it with marital money. So your income is marital money.
What if you put that money into a retirement fund or something?
If you mix it with marital money, you're going to have a hard time separating out the separate money from the marital money. So it makes sense if you want to, let's say if you got that money and you wanted to dump it into an IRA, for instance, don't put anything else in the IRA. Just keep it as separate. Let that money, if it's $100,000 that you got from a life insurance policy and you want to put that in an IRA, don't put any more money into it.
Okay, so you dump that money, let it do what it's going to do.
Yes.
But when you start adding your funds, it goes into that pot.
Exactly. And that makes it's not that it's impossible, but it is a forensic nightmare to try to separate out what is marital versus what is separate. It may be a little easier with an IRA because that's not an account that you're going to use on a regular basis. But like if you put it into just a joint savings account, or even into a savings account that you're putting marital money that you've earned during the marriage into that account, you're going to have a hard time separating that out, especially if you're using that account.
Note to the file, everyone. Now, and so speaking of kind of, notoriety and things that are amplified, social media, TV, whatever. Prenups. We hear that wonderful word, and you always think about celebrities and
Mhm.
athletes. Let's talk about prenups and the average citizen walking around. What are your thoughts, your suggestions for someone who is, we're 25, we're just getting started in life, maybe
Mhm.
don't have anything, haven't quite gotten that family member's estate or anything like that. So they're each starting at a place where it seems equitable.
Mhm.
What do you say to that couple of, should we be thinking about a prenup now, or is this really if you're more established and you have assets or things that are coming with you into the marriage? Like what does it mean, and kind of what are some of those ways of considering whether a prenup is an absolute necessity for someone?
So I think premarital agreements or prenups are good tools. Um,
And under any circumstances, no
Under
matter.
any circumstances, I think they're good tools. What I have experienced over the years is that, you mentioned, you're 25 and you're sort of just getting started. Those are actually, those, especially if they're short term marriages. Um, you got married, fresh out of college, and you bought a house together, and you got some furniture and those kinds of things. And but you only stay together, 1, 2, 3 years, no kids. Believe it or not, those are some of the most dramatic divorces that I have ever done, because all they have is stuff, and that's the only thing that they can kind of cling to. I think that the a premarital agreement is a perfect thing for those. Though, if you're not entirely sure that this is going to be the only marriage that you have, I know some people, younger generations, maybe we did it when we were younger too, call them starter marriages. Um, that's kind of crass, but I think I've heard people say it.
Mhm.
Um, and if you feel like, you're not 100% sure that this is going to last forever, get a premarital agreement. I mean, and here's the benefit of it. It sets out, you can set out very clearly how you want your things to be divided. What is considered separate is defined in the document. What is
Mhm.
considered marital is defined in the document. You also have to disclose all of your assets and debts at the time that you're signing this agreement. So you go into it knowing, like, okay, my spouse has, $100,000 worth of student loan debt,
Mhm.
which, for all intents and purposes is probably going to end up being their debt anyway. But if you get 2 or 3 years down the road, you don't want to be having an argument about, like, student loan debt. Your student loan debt's yours, my student loan debt's mine. Your credit card debt is yours, mine is mine. The only things that we're going to consider to be marital are gifts that we might give to each other. And you can define what that is. Like, I'm not saying that that's what has to be what's marital. You can define in your premarital agreement what is marital. You can also, in a premarital agreement, decide whether or not there's going to be any kind of waiver of spousal support, alimony.
Oh,
You can put whether or not, if you want to waive, if both of you agree, when we leave here, we're just going to leave with what we have, then you can waive alimony. You can do that in a premarital agreement. Um, you can't really do things like stuff with kids, because the courts always maintain jurisdiction over kids. So they're not going to let you put things like, you have to have a kid by, X date. And there's certain other things that are probably more salacious that they will not let you put into a premarital agreement. Well, I should say, that are not enforceable in a premarital agreement.
so someone
But
can ask you, like, I mean, we can put it in, but it won't, we cannot enforce it,
yeah,
or
it's
would you
not going to be
say we
enforceable.
cannot put that in?
Yeah, it's not going to be enforceable. Like, you're
Okay.
not going to be able to say how many times you have sex in a premarital agreement. That's not enforceable. People have tried, though. You'd be surprised.
I can only imagine,
Yeah,
not to be gender slandering, but
yeah,
yeah.
yeah.
Mhm.
And so, I think that premarital agreements are a really good tool. In some states, and every state's a little bit different. North Carolina premarital agreements last as long as you have it. Like,
Okay.
as long as you're married. In other states, premarital agreements might expire after a certain period of time, but we don't
Okay.
have that issue here.
And so what
And
you have, though, you can't modify it. It is where it is, but if you have a rapid change in circumstances or things like that, is there any tailoring of it, or is it really this is what we went into at that time thinking we needed?
so you can, but it's now. So after, let's say, after you've done a premarital agreement, you've gotten married, and then somebody has a bad illness, and it's the person who was like the primary breadwinner who had all of the income, and so your premarital agreement kind of accounted for that, and suddenly this person's unable to work, and you need to like do some things, change some things as far as the property distribution is concerned. You can do a post-marital agreement.
Okay.
Post-marital agreements are only property related, though. So you're not going to be dealing with alimony issues in that. So if you need to, that's kind of the only way that you're going to be able to kind of modify, so to speak, a premarital agreement, is by doing a post-marital agreement that sort of deals with the property issues. And that's assuming that the parties stay together, that they would do a post-marital agreement. There have been occasions where they did a premarital agreement and neither of them liked the premarital agreement at the point where they were separating. It was not beneficial to either one of them or whatever. And usually those are long-term marriages. And sometimes it's just because I actually had a case where they could not find the premarital agreement. They'd been married so long and had moved, and, lawyers were not required to keep documents forever. Most of the time it's going to be right about 7 years. And if you've been married 20 years, we don't still have your premarital agreement.
Well, in that case, any suggestions for what people can do, given that that's the reality? And then they call your office and they're mad. First of all, is the office still there? Second, you're like, so sorry, we got rid of those records. So what would you suggest people do? I mean, obviously it's safekeeping, but can they?
Yeah. Keep digital copies, put, each of you have digital copies, put it in the cloud, a cloud account somewhere. You can email it to a trusted family member that also might, have a cloud account to keep it somewhere. Safe deposit boxes are always going to be, just a great place to keep a hard copy of any documents. Safes, in general, just a safe in general is probably a good idea to keep documents, but safe deposit boxes are, if you just want to have a hard copy and not be worried about your cloud account getting hacked or something like that, you just safe deposit box, put it in the bank, keep it moving.
Okay, that's good. Yeah, because I mean, at a certain point, when it would be interesting if both agree that there was a premarital agreement, but can't find it, and then you're squabbling about what it said. So it's like, okay, you say that it exists, but neither of you want to admit what it included. So then you're in that train of he said, she said. And I'm assuming as an attorney, if you can't find records, you go with what the equitable distribution.
We go with what the law says. We just do it as if it's just a regular separation agreement where there was no premarital agreement. And I've actually had that situation happen. And we just ended up having it, the other party couldn't find it. My client couldn't find it. Nobody could put their hands on it. And I wasn't the attorney that drafted it. The other attorney wasn't the one who drafted it. And again, like I said, we're not required to keep documents forever. Okay. They don't get filed. So they're private agreements. So, if nobody has a copy of it, then we just got to act like it never existed in the first place.
And that's another interesting point of what you said. It's not filed in any court system. So when we sometimes think, and I think if you are not going through with that, again, what we have in our mind fantasy is like, oh, all of these things are some form of agreement that must be existing in someone's legal document, housekeeping, location or the courts. And you're like, nope, private agreements, that is your responsibility to keep. And so I think for a lot of people who've not had this experience, and hopefully you never do, but just going into it knowing, just like we need to be saving certain things so that we have access to them. This is obviously one of those. Now, to circle back, and when we talk about, I'm not sure how comfortable you are in just giving rough costs for what various types of services. I don't know if they're in certain categories, like, for divorces is this, if we're dealing with custody, again, is it protracted versus neat and clean? Like, any rough estimates for someone who's going in to say, if you have a simple uncontested divorce, this may be, and again, it may be obviously attorney by attorney differences in cost, but roughly speaking, what might some of these services cost?
So for an uncontested divorce where we're not dividing any property, it's literally just the dissolution of the marriage. At least in North Carolina, most counties have do-it-yourself kits, and they come with the instructions. And you only pay the filing fee and the cost. There's a filing fee. Currently in North Carolina, the filing fee is $225. To have it served by sheriff is $30, and there's a notice of hearing fee for $20. So you're looking at $275 if you want to do it yourself.
And it's legal. It's
Mhm,
above board if you
mhm,
follow the instructions.
yeah, and literally it's so we're not dividing any property, nobody's getting any spousal support, they're not dealing with custody or child support. It's just dissolution of your marriage, and you have been separated for that 12 months and a day. And like I said, you can walk into any clerk's office, and they can, I think pretty much all of the counties in North Carolina, I'm sure, have the do-it-yourself kits. I know the major counties do: Wake, Durham, Orange, Guilford, Mecklenburg. I know the Johnston, the big counties, that they definitely have them. Um,
Mhm.
but yeah, they have the instructions. They tell you, they're not, the clerks are not going to give legal advice. So if you have questions that require legal advice, you're going to have to talk to a lawyer. But if you're just getting divorced and you know where your spouse lives, and they'll give you the instructions on how to fill out the paperwork. And it's really simple. It's a lot of fill in the blank stuff. And then you get it to the sheriff's department for them to, well, most counties, they will, when you go to file it, they will give it to the sheriff's department along with a $30 fee to serve it. They'll get it out. They'll go out and serve your spouse. And if they are able to serve them, and the sheriff's department will send the return of service back to the courthouse, and then you get your notice of hearing, the date, or you'll get the date to do the notice of hearing. There are certain things that you have to do, like you have to send out the notice of hearing to your spouse so that they know when the divorce hearing is supposed to happen, so they can show up if they want to.
They don't have to.
If somebody's gonna contest it, they can contest it that day. It happens on occasion. Doesn't mean that the divorce won't go through, but some judges are a little skittish about having somebody show up and go, I don't think we've been separated for a day or whatever. Yeah, for 12 months and a day or whatever. And then they'll kick it to a different calendar or something like that. But doesn't mean you're not going to get divorced. It just means you might have to have a second hearing or something.
And then you have to pay for that hearing, but you may or may not need to bring in an attorney at that point.
You don't, so once you pay the filing fee, and regardless of whether it's a contested or an uncontested divorce, you're going to pay the $20 for the notice of hearing. It's just a notice of hearing fee. But once you've paid the $225, once you've paid those fees, that $275, majority of the time, you're not going to pay anything else to the courthouse.
Okay.
That's it. That's typically going to be it for your courthouse fees. You may need to hire a lawyer if it's a contested divorce, though.
So if it turns into it appeared uncontested, but then this person comes the day of and it's like all sorts of stuff, we're entering into a different arena.
And at that point, you may need to hire a lawyer to represent you in that.
Mhm.
And depending on what the person is saying is the reason why they feel like you shouldn't get divorced, typically will dictate how much the lawyer might charge. Because I just as an example, I had a client whose husband showed up for the divorce hearing and didn't want to get divorced, but it wasn't because they hadn't been separated a year. In fact, he acknowledged that they'd been separated for like 2.5 years.
Okay.
Yeah, it wasn't that. He just didn't want to get divorced. And that's not a basis for not getting divorced in North Carolina. He'd been properly served. They've been separated for the year and a day. And at first, this particular judge, who's a great judge, was going to kick it to the contested calendar. And I said, but judge, it's not contested, though. He just doesn't want to get divorced. He said, on the record, that they have been separated for more than 2 years. That's all we need. That's what the statute says. And she kind of hemmed and hawed for a second. She's like, yeah, you're right. You're right. And so they got divorced.
Like not wanting to is not quite the same as contesting it if you've done the letter of the law in terms of whatever the time.
Right.
Okay.
So that's when, but sometimes, people will come in with legitimate things and say, hey, this happened over the last year. And that's why I don't think we were actually separated for a year and a day. And that will get kicked to, a contested divorce calendar. And you may need to have a lawyer come in and, argue some things for you and present some evidence.
Now let's get into that year and a day thing. So intimacy, does that reset the clock, even if you're living separate?
No.
Oh.
There is
And
case
so
law in North
that
Carolina that says that isolated incidents of sexual conduct during the separation period does not toll the 12-month statute of limitations.
oh, wow. So if you have a spouse saying, "We hooked up, linked up 3 to 4 times during this year, but we still maintain separate. We didn't
Still live
reconcile."
separately. Still, what the court is going to look at in that situation, if somebody brings that up as the reason why they think they weren't separated, the court's going to look at things like whether or not, first of all, were they living together? Secondly, did they hold themselves out as husband and wife during that period of time? If all they were doing was having sex and were still living completely separately, and people didn't even know that they were hooking up or anything like that, like their parents didn't know that there wasn't any talk of reconciliation. There weren't any actions of reconciliation. They didn't spend holidays together. They weren't spending birthdays together. They weren't taking trips together. They weren't doing things that normal husbands and wives do. They weren't paying bills together, things like that. If they weren't holding themselves out as husband and wife, chances are the court's going to say, yeah, they just had sex.
Even with like text documentation or anything, they're like, still, you were not doing all the other things.
Right. I mean, and it happens. It happens a lot that, people will hook up again during that 12-month period of time. And usually that's when I get a phone call, frantic phone call, like, oh my gosh, I think I made a mistake.
You're like,
Like, it's
let me
okay.
guess. Let me do one guess, and if that's not it, then you can tell
Yeah.
me. But let me
And
go.
and I've, there's even been situations where one of the spouses, because they had kids together and like the other spouse, like maybe was living out of town or something, and they came and they spent the night in the house because they were spending their custodial weekend with the child, and they may have stayed in the same house for that weekend, and it didn't happen on a regular basis, and they weren't, and maybe even if it did happen on a regular basis, I would still argue that that person was coming in to spend time with that child. We were not spending time together. We were
Mhm.
not holding ourselves out as husband and wife. They went to their family's house at Christmas. I went to my family's house at Christmas. We didn't go to homecoming together. Like
Mhm.
all of those kinds of things that you would normally see couples do together didn't happen. Everybody knew we were separated.
Good. So do not be filmed in the Bahamas on a trip during that time
With
period. Looking,
with your
looking
family. You're going
right,
to cousin Bob's
cordial.
wedding.
Yep. 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 Okay. Or at least if you go to Bob's wedding because they're a mutual friend, you're staying separate. You're
Yes.
there because this is a mutual connection, but not we a room together. We sat at the table. We sat next to each other on the flight.
Mhm.
Like, yeah, okay,
Yeah.
okay, that makes sense. So it's like some things can happen where you can be in the same spaces in these celebratory aspects, but what is the intention? Is it because you're coming because there's a
Yes.
mutual thing and it's not you're coming together?
Right.
Okay.
Right. Right.
Okay, got it. So again, for those listening, if you're going this route, it's uncontested, can be relatively inexpensive. I'm assuming the meter starts ticking though when we get into anything's around disputes. And it's not just that I don't want to get married or get
Mhm.
divorced, as you said. When we bring into kids, when they're assets, that's when
Mhm.
we're going to be expecting you as an attorney. First of all, they need one,
Mhm.
and then you all devoting the time to help them to either understand what's going
Right.
on, disentangle, think about the resolution. So that's when the costs start to increase.
That's when the cost starts to increase. Um, Particularly when when we start talking about litigation, so going to court.
Mhm.
Um, my motto has been for 20 plus years that court is bad. Once you go to court, you'll always be in court. So, and particularly when there are children involved. So
Okay.
the more time that you can spend trying to work out a negotiated settlement, number one, it's going to cost you less money. And that's not to
Mhm.
say that it's going to be cheap, but it's going to cost you less money.
Mhm.
Um, it is going to cost you less time. And again, that's not to say that it's going to happen quickly, but it will be less time than you'd spend trying to deal with the court system. And you will actually have more control input into the outcome.
Okay.
Whereas once we put it in front of a judge, it's up to the judge. It's at, all we can do is put forth the evidence, put forth the best picture that we can put forth, and then it's up to the judge. And sometimes you don't always have the facts on your side. And or you might have the facts on your side, but you may be just the kind of personality that judge hates.
Right. And it doesn't matter.
And they don't believe a word you're saying. You could have all the evidence you want, but that judge is looking at you cross-eyed. So, just
And there is
because
that bias that
yeah,
happens.
they're human beings, and I think, and that's one thing that I constantly have to remind my clients of, is that these judges they're human beings. They come into the courtroom as, the neutral arbiter of fact, but also they have families at home, and they
Mhm.
wake up some days and they're not in a good mood, or they wake up, they've been up all night long because their kid got sick. um it's stuff like that. So you have to be very careful about making sure that if there's an opportunity to resolve it outside of court, that you really kind of put a good faith effort into doing that.
And is that where mediation, I've
Mhm.
heard that term, is
That's
that what
exactly where I
that
was headed.
is to get you from the to hopefully prevent you from having to be in front of that judge? Is that what
Yes.
that is for?
So a mediator is someone that we hire. They're a third person. They're typically going to be a lawyer in the family law realm. We're going to typically hire another family law attorney who is a certified mediator.
Uh-huh.
Um, and there's a course that we take to become mediators. It's a 40-hour course, and you got to do some volunteer hours as well. But that person's job is not to make a decision, but to basically act as a referee, to kind of go between the parties to try to get you to resolution. Those sessions can happen in person. They can happen virtually. I've done a number of virtual mediations since the pandemic. They work just fine. Um, Sometimes I think the virtual mediations work better because the parties are not in the same building. They're typically in their own homes, and so they're more comfortable. And and when you're more comfortable, you're going to be a little bit more amenable to settlement.
Okay.
But yes, mediators are great tools in terms of trying to find a way to bridge the gap. Um, Sometimes that is a very large gap that we haven't agreed on anything. Sometimes it's a very narrow gap that we've agreed on almost everything, but we're stuck on these few things, and we need a mediator to kind of get us across the finish line. So yeah, we use mediation a lot. Mediation, we have to pay the mediator. The mediator's charged by the hour, and typically the parties will divide those expenses equally. And every mediator charges something different. I have found that sort of the more mid-price mediators are typically very experienced in family law, very experienced in family law litigation, and can get us to the finish line without having to spend, $300 or $400 an hour. Works out just fine. Sometimes we want the higher price mediators for the more complicated cases. Sometimes it doesn't matter.
Mhm.
The mid-price mediators are also very, very intelligent. Majority of the time, my experience with mediation is that more than 90% of the time, those cases will settle in mediation.
That's good.
Yeah. And I tell people all the time with equitable distribution trials, and this actually even happened. I was on calendar call this week, and a judge was asking about a court date. It actually was this morning, asking about a court date that was like later on, or early part of next year. And there was a trial that was on a particular date. And I think one of the attorneys asked, because they wanted to be first up on that day. And one of the attorneys asked, is it an equitable distribution trial, which is the property distribution trial? And they looked and said, yes, it is. And the reason why she asked that is because majority of the time, those cases don't go to trial. So if we look at the calendar and see that there's an ED trial on the calendar ahead of us, we can almost guarantee that those cases, that case is not going to go. Not 100% of the time, but more than 90% of the time, those cases are not going to trial. The only time I've seen those cases really play out is, like I said, when it's a complicated case. There may be some businesses involved, and a bunch of expert witnesses, and a lot of money involved, and the parties just can't. They've gone to mediation, and they just can't reach an agreement because there's just so much happening. But your average equitable distribution trial is going to settle in mediation. There's another tool that I used to use a lot. I used to actually teach a course on it. It's called collaborative divorce.
Mhm.
Um, and it's just a different way of negotiating. It works really well when there are children involved. And just very quickly, in a nutshell, mediation is sort of your typical negotiation, kind of your tug of war. Everybody's kind of trying to pull the other person to their position or whatever. Collaborative divorce is less about trying to pull the other person to your position than it is about meeting needs. So I give the orange is the example that I use. Two kids fighting over one orange, and mom walks in and says, "Hey, stop all that noise. What are you fighting about?" And the son says, I want the orange. I need the orange, blah, blah, blah. And she says, what do you need the orange for? And he says, I want the orange because I want to use it in my composting garden. And I want to use the orange peel for that. And the daughter says, well, I need the orange because I want to make fresh orange juice. She needs the juice. He needs the peel.
Mm-hmm.
So it's about identifying the need
Mm-hmm.
and trying to satisfy the need, as opposed to one person gets 100% sort
Mm-hmm.
of thing.
Like, we can give you that peel, but we need to
Yeah.
give you the
Yes. You
inside.
need the pulp, you need the peel.
Yeah.
Exactly. So I've done quite a number of those cases. Haven't done as many over the last few years. I think the pandemic had a little bit to do with that, because those are, and mediation typically happens in a day, maybe 2 days, but typically it'll take 1 day and you're done and people walk out with a signed document. Collaborative is more of a, we have multiple sessions. And so they're usually about 2-hour sessions, and we tackle a topic at that session. It could be that we're dealing with support, and it could be both child support and spousal support, but we're basically using all the same numbers. And so some of the tenets of collaborative divorce is that everybody signs signs a pledge. And the pledge basically says we're going to work above board. Everybody's going to have the same information. We're not going to hide things from each other. We're not going to be dishonest. If your lawyer finds out that you've lied about something or you've hidden some information, they have an obligation to withdraw. Now, I can't tell you why I'm withdrawing from the case, but the other lawyer is going to know if I withdraw in the middle of the case is because you probably lied about something.
And when you see that where folks are getting different attorneys, it's often, it's because
Yeah.
of that. It's not because the person decides you're not or could it be that the person decides you're not the attorney for me?
Sometimes that happens in like classic litigation cases or classic, like, mediation cases. Sometimes it's because they stop paying and that lawyer's tired of chasing them down for money.
Mm-hmm.
That's actually probably more often than not. But sometimes it's that, as I said kind of early on, they're not hearing what they want to hear.
Mm-hmm. Mm-hmm.
I'm going to tell you what you need to hear, not what you want to hear.
Yeah.
And, after many years of experience in doing this, I can tell kind of right away whether or not this person is going to hear what I'm saying or not. So I may decide before things get too far that this isn't going to work out, because I can already tell your expectations are in the wrong place.
Yeah.
And I'm not going to be able to manage your expectations. Collaborative divorce kind of gives everybody an opportunity to have the exact same information. We literally create notebooks where everybody has the same documents. So we're all working off the same page.
Mm-hmm.
We're working with the same numbers when it comes to support issues. So everybody can see what's there. We're not going to be able to get blood from a turnip kind of situation. We see what's there. We see what your income is. We see what my income is. We see what the normal bills are. Everybody's working from the same page. So we can see, we need more money to go towards the kids than we need to go towards me. Or I don't need anything at all. Let's put it all towards the kids. It's a great tool, but it just takes a little bit longer. But it also,
you're dealing with reasonable people. Like, when you're explaining it sounds like I would need to be reasonable and my
exactly.
person would need to be reasonable. Yeah, like, if
100%.
someone's not playing well in the sandbox, does this work?
It
'Cause
doesn't. Well, I shouldn't say it doesn't. It doesn't work easily. One of my most memorable collaborative cases took 8 months, and it normally doesn't take that long. It takes somewhere more like, 6 to 8 sessions, which is maybe 10 weeks, something like that. Yeah, if somebody's not being above board, if they're not being honest about the situation, it can be difficult. It's not impossible. And a lot of that requires you to have representation that's being really honest with you. Your lawyer's got to be super honest with you. And you may have to have, as a lawyer, we may have to have a couple of very difficult conversations with our clients. But that case actually did resolve. But most of the time, yes, the parties have, domestic violence cases, you don't want to do collaborative law. You can, but you don't want to. It's not going to work very well because they can't even be in the same room together. So it's not going to work very well. Cases where there may be some untreated mental health issues that, are very volatile, for lack of a better word, it's going to be difficult. But the one good thing about collaborative is that we can bring in experts. So we can bring in joint appraisers, we can bring in joint mental health professionals, we can bring in, people who deal with custody issues. We can bring in all kinds of people to help us through the process. And
Mhm.
they're jointly paid for, and they're jointly agreed upon, and they can help us get through the process. But like you said, everybody kind of has to be willing to collaborate, and that's why it's called collaborative law.
And have you ever had to check in and say, "These people are not really living up to the collaborative, let's
Yeah,
go another route?"
I've had to withdraw from cases.
Oh my gosh.
So yeah, I mean it's hard because I feel bad. You know, I feel like the collaborative process is something that people should use more often, particularly if they've got kids, because it really does benefit kids a lot. I had a case many years ago. In court, judges typically will divide up custodial time based on where the child spends the night. These
Mhm.
parties didn't care about where the kids spent the night. They cared about how many hours they were going to have. So their actual custody agreement was dividing up actual time. You know, one parent traveled a lot, and so, you know, maybe they want to have more hours during the weekends to do this, that, and the other during the day, because when they're asleep, they're not really doing anything. The kids are
Right.
asleep. So
Mhm.
they literally divided up the daytime hours. That's an unusual thing, and that's not something that a judge, I think, is ever going to do.
But in this process, you all wrap it up.
Yeah, we were able to be a little bit more creative in that process because it ends up in a private agreement that doesn't get filed with the court.
Oh, okay.
It's still
Okay.
it's still enforceable. It's a contract just like any other contract, but it's what they've agreed to. And that
Okay.
client never came back to me later on, so I'm assuming everything worked out fine.
Mhm.
She never came back
They
and told me to
they
do any
usually
more.
come back to you, like, they try to people for symmetry purposes, like, they try to stick with their same attorney.
Typically,
Okay.
typically, I mean, if the representation went fine, then yes, typically they'll, if there's a problem later on, they'll come back and be like, "Hey, you remember this? Remember me?
Mhm.
You know, you did a separation agreement for me, or you know, you handled my custody case, you know, X number of years ago. Can you help me with this?"
Really quickly, as I think about when I said earlier about resources for families that are in
Mhm,
need. So let's say, and and I'm making a blanket assumption here that in general, when people think of securing an attorney, they have some assets and ability to do so.
mhm,
Let's say you're working with either someone who's extremely low income or just do not have the resources to hire an attorney. And obviously they can't do the really simple divorce process or anything, and obviously when we get to child custody and
mhm,
things, what resources or what ways can someone secure what they need, but they literally just don't have the money, they don't have family
mhm.
support, they don't have that ability, but these things still need to happen? Like, what do
Right.
you do as an attorney when someone comes to you, they can't afford you, but they still need these things to happen?
So, there are a couple of different things that can happen. The courthouse, at least in Wake County, has a kind of a do-it-yourself clinic, so to speak, that can help. They don't provide legal advice, but they can help kind of walk you through filling out certain documents. There's another organization, Carolina Dispute Settlement Services, run by two really good friends of mine, Diane and Jeff Siegel, who also do kind of do-it-yourself clinic. And again, they have lawyers who will, based on your income, and I think they have some situations where they might have a sliding scale for certain things for lawyers to do in terms of cost, that they will help fill out paperwork and things like that. The other alternative and I don't know if a lot of people even know that this is available, is to check at the law schools in the area. I know North Carolina Central has a clinic, and it is supervised by a licensed attorney, in North Carolina. But the students, the third year law students, are actually the ones under the third year practice rule who are doing the work, and they're meeting with the clients, and they're under the supervision of a licensed attorney. So the laws, check with the law schools. I think Campbell has a clinic that does something similar. I know, like I said, I know North Carolina Central does, and I believe UNC's law school may also have some sort of like a similar clinic.
Oh, very cool. I don't think I ever knew
Mhm.
that that was a possibility. Or and so the services they're getting with the law students, it doesn't need to be, and I don't know if this is the right word, signed off by the attorney, or
Mhm.
what they're
Mhm.
doing, is it representative of just like them talking to you, but they're just a third year law student, or how does that work?
It's similar. It's sort of a little bit of both. They are working under the supervision of a licensed attorney, so it's that attorney's job to supervise.
Mhm.
So, if there are any court documents that get filed, the attorney's going to sign them.
Okay.
Because they're the only one with a license. But that, if there's a hearing, for instance, like I practiced under the third year practice rule when I was in law school, through the clinic at North Carolina Central University School of Law. And we did, I remember that particular year we were doing domestic violence cases. And so one of my very first trials was a domestic violence hearing. And, my supervising attorney was sitting at the table next to me, but I did the direct examination, entered the evidence, did the cross-examination, did the opening, the closing. I did the whole hearing, but I had a supervising lawyer literally sitting right next to me.
So they could step in if needed.
Right, exactly. And, if there, I believe that we did some like separation agreements and things like that. So, I was working with family law clinics. So North Carolina Central has like a family law clinic. They have a civil clinic that's for other civil matters outside of family law. And I believe they also still have a criminal clinic. I believe they still have it, a mediation service as well. So, the law clinic at Central is pretty wide ranging in terms of the kinds of things that they offer. But again, like I said, any law student who is interning with a law firm can apply to practice. Not any law school student, any third year law student can apply to practice under the third year practice rule, as long as they have a supervising attorney. And many of us, outside of what we were doing in the law school, were working with lawyers who would take us to court. I had interns myself under the third year practice rule that I would take to court to do like simple divorce hearings or, stuff like that.
Awesome. And I'm going to
Yeah.
shout out my younger sister who is in her third year of law. She's not doing family law, but if this is something that she is getting in
Yeah.
contact with, that's super exciting. I didn't even know it was a possibility.
Mm-hmm.
So definitely shout out to you all in the legal field, and her in particular, as she is on her pursuit to join your ranks.
Yay, good for her.
Yeah. So I want to be respectful of your time. We've talked about some of those key aspects. We haven't really gotten into the touchiness of child custody or things related to, as you said, abuse of any sort, whether it's the domestic, whether
Mm-hmm.
it's the substances, as you said, all the things. I don't know if there's any way to encapsulate some of those more thorny issues in terms of how your practices work. But I would love to hear it. But I know that those can be really complex situations, and likely you'll say, consult an attorney to learn more. But if there are any high level things that you think would be good for people to just know or consider when they're dealing with, like I said, those more touchy
Right.
potential issues.
High level, if there's a domestic violence issue happening, practically all of the courthouses, I think at this point, have like a domestic violence unit or a place that you can go at the courthouse to deal specifically with domestic violence cases. I know Wake and Durham counties particularly have like a domestic violence unit. Also, so you want to definitely take advantage of those resources. I know in Wake County, domestic violence unit uses Interact. They collaborate with Interact as well as with legal services, and you can get help with kind of the more practical parts of dealing with a domestic violence situation, getting away, safety, things, for your children, if there's, concerns about kids as well, with help from Interact. But also, you can get legal representation through legal services. That's one of the things that legal services does, is domestic violence cases. One of the many things that legal services does. So those are the kinds of resources, you want to find your kind of local domestic violence protection organization in your county to be able to help, like I said, with the practical aspect of getting out of the situation and finding someplace safe to be. But also then being able to deal with the legal issues of like restraining orders, whether that is a civil restraining order or a criminal, because they're actually two different things. They kind of do the same thing, but they happen in two different courtrooms and they have different implications. From a substance abuse perspective, again, I think it's a matter of if you are the person with the substance abuse issue and you're dealing with particularly a custody situation, if there's no other reason for you to find help with your substance abuse issue, your kids should be it. I think judges are more aware of the fact that substance abuse is a disease.
Mm-hmm.
Alcoholism is a disease.
And
Drug
it's
abuse is a
chronic.
disease.
And it's
And
chronic.
yes, And so if you are taking the steps to get yourself on track and get sober and all of those things and get into recovery, I can promise you judges are going to be a lot more compassionate, because what they don't want at the end of the day, judges don't want to separate kids from their parents.
Mhm.
But they're also aware that like substance abuse can cause problems that can put kids in danger and can put the other parent, the other spouse in danger. So they want you to handle those situations. So if there is whether it's an inpatient or an outpatient AA, NA group that you can get in touch with to help you with that, do it. If you are the partner or the spouse of someone with a substance abuse issue and you're dealing with children in particular, again, I always, well, in every case, regardless if there's an abuse issue, I recommend therapy to everybody.
Mhm.
Going through these kinds of cases is difficult for anyone.
Mhm.
If you have a therapist, make sure your therapist knows what's happening.
Mhm.
And particularly if you're going through litigation, make sure your therapist is involved with you on that, because there are just coping strategies that I think that are going to be very helpful to you in being able to manage the anxiety that happens going through these kinds of cases. If you don't have one, get one. If you
And
can't,
yeah, and I was just gonna say, and I did another video with a mental health therapist, and he gave numerous resources for
Mhm,
various income levels. So thank you
yes,
for repeating that.
and going through these divorce cases, I've many times recommended divorce care, which is like a group. It's kind of a group therapy kind of situation, and they usually are in churches. Um, there are a lot of divorce care groups, and they have different names. But Google just divorce care groups, and
Mhm.
you'll probably find a number of them in your area. And they may not be like the best places for like actual mental health therapy, but they will provide you with some resources, as far as like other people going through similar situations and things that might be helpful to you. Just from a practical perspective, I will caution people not to take their legal advice from anybody going through those group sessions. Everybody's case is different, and you don't want to take your legal advice from other people. You want to take your legal advice from your lawyer.
Mhm.
But certainly, I'm a big advocate for any kind of therapeutic group that is going to be helpful to you, is always going to be helpful to your case.
Mhm. Okay.
I still have, I'm sort of surprisingly had a conversation not too long ago where I had to remind someone that judges don't, they're not going to look at you poorly if you are in therapy, if you are someone that suffers from some mental illness, somebody who's dealing with depression and anxiety, and you're taking those medications and you're, talking to a therapist on a regular basis, that means that you're taking care of yourself. They're not going to look at you like you're not a crazy person. You're doing what you're supposed to do.
Absolutely.
So do those things, be self-aware, and be someone that says, I need to be better for my children and for myself. So
Mhm.
those are the kinds of things that I try to get people to tap into, those kinds of resources, therapeutic resources for whatever, whether it's for an abuse situation or for just your general mental health. And even if you're not somebody who has sort of more obvious mental health issues, therapy is always a good thing when you're going through the end of a relationship.
Mhm.
Because when you're in my office, you're dealing with the end of a relationship, whether you were married to the person or not. If you just have children with that person, you're dealing with a relationship that has gone sour at some point, if you're in my office.
Mhm.
So therapy is always going to be a good thing.
Yeah, and the new scary unknowns of what life looks like
Mhm.
after, again, all the commingling, in terms of co-parenting and stuff like that. Like it is a new direction for people that often they've never been in, and so it's a
Right.
situation that is hard to prepare for. And so I agree, just seeking out those therapeutic services, and I'll be sure to link back to that interview I did. It also takes away some of the misperceptions that you have to be
Right.
mandated to do those things. You need to be mandated to go to a support group, versus, as you said, going on your own accord and it
Mhm.
being looked upon favorably because you are taking the time to really build up
Right.
yourself and to give yourself those coping skills.
One more resource before because it'd be terrible if I forgot them. Um, Safe Child in Wake County.
Yeah.
Um, I was a volunteer, and I used to be on the board of Save Child. Save Child stands for Stop Abuse for Every Child. And the resources at Save Child are unbelievably good. They have resources for parenting programs. They have resources for not just dealing with being a parent or having children, but like being a parent. Like if you're a first time mom, they have resources for first time moms. They have
At all
resources
income
for
levels? At any
yes,
income level?
yes.
Okay.
There's only, at least as of my last check, there's only one program at Safe Child that actually requires payment, and that's the men's program. And that is a program that is for men. And most of the time, the men in that program are court ordered to be there. And it's not as it's I don't think it's I don't even remember how much it costs. It's not super expensive, but they're typically court ordered to be there because there's either some parenting issue or there may have been some sort of child abuse issue that's happened. The other programs are free, and so they have resources for people who speak Spanish, um, which is great, in particularly in the Wake County community. And one of the great things about Safe Child is that when there is an allegation of child abuse, they are kind of a one-stop shop. So this child doesn't have to keep telling the same story over and over and over and over again.
Mhm.
They have it set up so that this child can meet with the appropriate medical professional and kind of mental health professional, and the people who need to hear the story are watching from like closed caption. So or not closed caption, but from closed circuit TV.
Mhm.
The law enforcement, CPS, everybody that needs to hear the story is hearing that child say it one time.
Yep, and it's so it's
They
not
don't
that
have to repeat.
re-traumatization over and
Yeah,
over again.
exactly. The DA's office is present. All of the legal people that need to be there, the medical professionals that need to be there, they're already there.
Mhm.
It's a huge resource. I wish every county had a Safe Child, because it's such a huge resource for children that are going through that situation. And it's also a great resource for not just for the children who are going through abuse, but the parents who may also be, experiencing that same abuse in the same household. That's Safe Child is an excellent place to be.
In addition to it being for those in need, you're saying that there are some services for people who are just doing regular parenting function
Mhm.
and needing resources?
Yes.
So it's not necessarily your child is in danger or you're going through an extreme
Right.
situation. It is if you're looking for positive parenting practices.
Right. Exactly.
Okay, excellent. This has been absolutely lovely as always. We did talk at the very beginning before we started recording about some of those things that like legally parents might need to think about for their families. And so they're not necessarily areas you cover, but would you just, go on record of saying, if you have a family, you might need to be thinking about this, and this in terms of kind of legal documents or things like that. So
Mhm.
any closing thoughts in terms of resources that, people may need to have in their lives, especially as we're parenting, for some of us, these children who are under 18 to make sure we have in
Right.
place.
I think, particularly with parents, the thing that I find most challenging, I think, is dealing with the communication between parents. And I'm sort of looking at this from the perspective of maybe you haven't gotten to court, but that might be something that might be on the horizon. Communication between parents is always going to be the thing that is going to sort of set the tone for how a custody matter might go. And not just between, I shouldn't say just between parents, communication in general. And that could be between the parents, that could be between the parent and the doctor's office, that could be between the parent and the child's teachers. Keeping track of that communication is so important. Keeping track of, their grades. I know that they have, schools have these classroom dojo and these other
Mhm.
programs that parents use to keep track of what's happening with their kids, with their homework, with their grades, with testing and all of those kinds of things. And if you're the parent that's not typically the one that's checking that stuff, you should probably start doing that. If you're the parent that doesn't typically
Yes,
show up for the parent teacher
I show up
conferences,
for it all. I'm
you
there.
should,
I'm
you
there.
should probably do that.
Mhm.
And I think that that's if there's one thing that I think parents, and I don't want to call it a mistake, but I think that it's a comfort level, probably it's a better way to put it. Parents get very comfortable with one parent sort of always running the show when it comes to certain things, and they just kind of ignore it. And
Mhm.
unfortunately, by the time they end up in my office, that parent that has been running the show is like, I've been running the show, and here's all the evidence of that. I think judges are aware that that's kind of the dynamic in certain, in marriages and partnerships and things like that sometimes, but You don't want to be that parent that doesn't know who your child's teacher is. You don't even know her name or his name, and you don't know who your child's doctor is. You don't want to be that parent. You don't want to be learning that stuff the night before you go to trial,
Mhm.
because that doctor's never seen you, and all the medical records say, the child has come in and mom brought them in. Being involved, and not for nothing, it also, it's not just for purposes of kind of documentation. It also makes you more present for your child.
Yes, thank you. And again, and it depends. I mean, sometimes you got dad because it's easier for him to be there, but it's
Mhm,
the same thing.
exactly.
Like it doesn't matter which parent, but it's like you're so tuned out that then, like you said, when you get to the point and they're like, I want joint custody, but like you said, I don't know who their doctor is. I actually don't know what grade they're in. Like you said, I don't even know their teacher. Like, okay,
Yeah,
that doesn't change anything, but you gonna have a lot more to learn and prove at some
right.
point.
And it doesn't mean that you can't get joint custody, but it
Mhm.
does mean that you're gonna have to work a lot harder to
Mhm.
convince this judge, if that's where we are, that you can handle it. Not that
Yes.
you're a bad parent. It's not even that you're a bad parent. It's just that you've not made yourself available in that way. So now we're talking about a child that's going to go between two households, and you've never made yourself available in that way. You got to be able to convince that judge that you can do it.
And again, like I said, it's no judgment against you, but it is that you're going to have a really, really steep learning curve, that ramp, trying to
Yes.
figure it out in the moment when the child is there. And you're like, wait, which school are you at? And of course, kids
Right.
know they're like, I'm at such and such elementary, and my teacher is, so they'll tell you, but
Yeah,
it's like scratching your head, like, I don't know. If you say so, that's cool. Um,
exactly.
yeah, okay, so that's good, to just think about, like I said, the documentation being present, things like that.
Mhm,
Legally, wills, powers of attorney, all those things, is that something that you recommend that people obviously, when they have assets or certain things,
mhm,
but again, when you have children, having that sort of stuff set out in some form of a document so that your wishes are known at any point, kind of if you're alive, if you have to
mhm.
pass, that sort of thing. So is that one of those baseline things that if at all possible, you recommend families have done?
Yes.
Okay.
Yes, I don't do wills, but I certainly think that, and typically when I get to an end of a case, I will tell clients, if you have a will, you need to update it,
Mhm,
because
mhm.
your will probably had your spouse in it, and you need to change that. But
Yep.
I think we talked about before with the premarital agreements, you can actually put language in your premarital agreement that deals with some things that you might put in a will, particularly if this is like maybe your second marriage
Mhm,
and you've got kids that you want to make sure that your kids still inherit from you.
mhm,
You might draft a will that gives your new spouse something, but you want to make sure that your premarital agreement also kind of backs up whatever it is that you're going to put in your will.
mhm,
Wills cannot dictate who gets children when somebody dies, but they can certainly be dispositive to a court of what that person's wishes may have been.
yeah,
If you want, grandma to take over custody in your death, then you're gonna first of all you're gonna the child's father or other parent is going to have paramount rights. But if they haven't been in the picture, and
mhm,
let's say grandma has always been in the picture, grandma's going to have it's going to be, she's got to jump a constitutional hurdle, but it's not going to be as hard if that other parent hasn't been in the picture the whole time. So,
okay.
yeah, wills are definitely, again, like premarital agreements, always a good thing to have. And, I know people think that, you've probably heard it on many, many television shows, oh, you're already planning for the divorce. Divorce happens.
Better to be a little bit more prepped than
Hmm.
caught unawares and trying
Yeah.
to figure it all out, and including the emotionality at that moment.
Yeah,
So,
exactly. Exactly.
mm. Okay.
Exactly.
Well, again, I thank you so much for your time. There's so many other avenues that the conversation could have taken. And I think, overall, it is that if you need to get to the point where you're securing an attorney, it's come likely at the end of a long road, and that there are ways that it can be empowered. If there's resolution, That's great as well, but just recognizing that attorneys such as yourself are present to really help people to think through, because you are the objective party. You're going
Mhm.
to be asking the questions or making them think in ways that, again, if it's highly emotional or all sorts of, complex issues, can be challenging. And that, as we've pinpointed, there are numerous resources that if people are like, I financially can't, but I need to do this anyway, that you're not stuck. And I think that's it for a lot of us. Like I said, the legal system, any of that is feels so scary, because I think it is often we think finances. So
Mhm.
thank you for illustrating the various avenues and opportunities. A few of these things I'll follow back up with you, and I'll likely link them in the comments, with the caveat that she works in Wake County. She's also in North Carolina. So if you're in another state or in another county, things may look and sound very different. This is a startup of a conversation. It's up to you to consult your legal representatives in your locality to get what is needed. So with that, I thank you again for your time and really appreciate it.
You're welcome. I really enjoyed it. Thank you for asking me.
Thank you. If you enjoy the content of this video, please be sure to hit the thumbs up to like it, as well as consider subscribing to my channel for additional content.